Hi, my name is Amanda Rocha. I am an estate planning attorney in California, and today we are going to discuss what happens to your 401k when you pass away. First, before we get into anything else, I wanted to let you know you can contact me in several different ways with any questions that you might have with regard to estate planning. You can reach me through my website, www.amandarocalaw.com, or you can reach me on Instagram or Facebook at Amanda Rocha Law, or you can comment down below. So first, to get into it, a 401k, when you fill it out, you have to generally say who your beneficiaries are going to be. You can choose one person or multiple, and when you do that, you choose the percentage on which they will receive. So one person would get 100%. Two people, you can choose 30-70, you can choose 50-50, 25-75, you get the picture. Most people will only have 1 to 2 people, sometimes list all of their children as well. Point being, you list beneficiaries when you have a 401k. When you pass away, whatever the beneficiary designation was will be honored. Whether you go through probate or whether you don't, that designation will be honored. If you have an estate plan or if you don't have an estate plan, the beneficiary designations that you've made with your 401k company are going to be what matters. So to put this in other terms, if you have a will or a trust and you document in your will or trust, I want my 401k to go 100% to my son and 0% to my daughter, and you've told the 401k company that you want 50% to each, the 401k designation is going to be what is followed, and it doesn't matter what your trust says. The only time it's going to matter what your trust says, there's actually a couple of situations. One is if you fail to name a beneficiary designation at all. Two, if the person or persons that you've listed as your beneficiaries are no longer living or able to receive. Or three, if you've listed your trust itself as the beneficiary, in which case your trust would dictate where that money would go. Another thing that you need to be made aware of with your 401k or other beneficiary designation documents like other retirement accounts or insurance policies is while the whole number is counted toward your probate total, which is a completely different issue. I got into that in some other videos and I'll probably cover it multiple times again. While you have to count your total amount toward probate, it is not put through probate. So it's accessible even if your estate is going through probate. So let's say you designate 100% of your 401k to go to your spouse and you have no other estate plan, or you have an estate plan that is will-based, so it has to go through probate. Your spouse can access the 401k funds during probate because it's not going to be tied up in that process. If you have any other issues with your 401k or any unique situations or questions, feel free to comment or reach out to me in the ways that I initially told you. And I hope that you have a nice day.